Hi, welcome back to Space Thoughts. Going to talk again about the Artemis Accords. There's been some new information that came up. More detail has been released about what these Artemis Accords are going to look like. And I'm going to go over a presentation that NASA actually put together. Presentation, more or less, a web page, just basically a fact sheet that basically discusses some of the principles of the Artemis Accord. But before I get started, I want to thank my subscribers for subscribing to the channel. It definitely helps get the word out, and it helps the algorithm as well. So again, thank you. And like I said, please tell your friends about this, share the video, like it. And again, every year your support does help this channel become more visible, and that's encouraging for me, knowing that this channel is getting out there. So we're going to talk about the Artemis Accords again. And last week I talked about the Artemis Accords and what I thought some of the principles that might be within the Artemis Accords based on principles for space resources that the NASA Advisory Council laid out. And I wasn't completely off on a lot of them. Some of them are actually in there, as we'll see in a moment. But what I want you to understand is space resources and the Artemis project are combined. They're two things. And I think Artemis program is really laying the foundation for commercial space activities, in particular space resource activities. So yeah, we're going to do the side-by-side screen again, and let me get back up here and start at the beginning. The Artemis Accords, and this is the fact sheet that NASA put together for this, and I'll post a link in the description so you can go and look at it afterwards. There's actually a PDF you can download as well. So the principles for a safe, peaceful, and prosperous future. That's kind of the headline of this fact sheet, and it lays out the principles of what the Artemis Accords are going to look like. Now, we haven't actually seen the document that these nations actually signed with the U.S. Understand, these are bilateral agreements. In other words, agreements between two states, and not multilateral, meaning an agreement between multiple states or more than two states. So basically what the U.S. is doing, they go out to a country and they want to sign on to our Artemis program and ask them to sign the accords, and they do that, and they go to the next country, and so on and so forth. And actually, this is an approach I've been advocating for a while. I'm not the first one who's advocated for the idea of bilateral agreements for space security and space-related matters, but I have been pushing for it for quite a long time. So it's good to actually see this being used in the context of the Artemis Accords, which is going to, like I said, lead to, in my opinion, a lot of outer space development. Just look at one of the first principles on peaceful purposes. This is Outer Space Treaty right here, right in the Article 1 of the Outer Space Treaty. Outer space to be used for peaceful purposes, and this basically, this basically reinforces this. And I want people to understand that the Artemis Accords aren't replacing or supplanting the Outer Space Treaty and some of the other treaties, as we'll see further in here, but actually they're building out on them, and in a sense building a framework on them from the bottom up. When I talk bottom up, again, I mean from the state level versus the international level with treaties and other methodologies. So the first one is peaceful purposes, and it speaks for itself. This is what the whole Artemis program is about, to pursue these space activities in a peaceful manner. Transparency. This principle basically says members who sign on to the Accords or to the Artemis program are going to be transparent. What are your space policies? We want to publicly see what your national space policies are with regards to things. Now, there's a big caveat in this, because national space policies have two faces. One is the public face that we see out there, and there's also the classified version. For example, PPD4, the National Space Policy of 2010, has a classified version of it. It isn't what is out there right now is actually, just what is deemed to be unclassified or for public consumption. There are still portions of the PPD4 that are unavailable to the public for various reasons. And same thing with other space policies. The 2006 space policy, for example, the classified version still hasn't been released. However, you look back at some other space policies, like the original Eisenhower space policy has been declassified, or at least most of it has, and the National Space Policy by the Jimmy Carter administration has been declassified for the most part. So those are things you can actually go in and see. The space policy for the Reagan administration, I still think there might be some areas that are still classified as well. But understand, even though the Artemis Accords are coming out and saying we want transparency in these types of things. We don't want, we understand there's probably going to be some classified matters of policy that these states don't reveal. And that's kind of, then that goes back to state interest. Interoperability of systems, and this is a technical area. We're talking about standards here. When I talk about standards, I'm meaning, will one piece of equipment work with another? And I think the best way to relate this to is computers and the internet. There are standards so that everybody can communicate. I wouldn't be talking with you or posting this video if it wasn't for standards. And the same thing as the idea of the Artemis Accords is we want to develop certain international technical standards so that equipment from one state can work with equipment from another state without a lot of problems, and that makes everything easier for everybody in the long run. So understand when I say standards, I'm talking about technical standards. For example, I belong to a consortium that deals with satellite servicing, and one of the issues that the consortium look at is basic standards for actually performing these remote servicing missions in orbit, whether it's refueling, repair, or whatever. Satellites and the servicing vehicles want to have certain standards. So that's another example in the space arena. Emergency assistance, and this is kind of fleshed out, and you notice the reference to the agreement on the rescue of astronauts, and return of astronauts, and return of objects launched in outer space. Again, this is building on current international treaties. It's not supplanting it, but reinforcing it. Now, one thing I will note is the question, what about commercial, and I'll use the term commercial astronauts very loosely. What kind of rights do they have? Because commercial actors, or what we call them right now, spaceflight participants in U.S. law, really aren't astronauts in the international sense. Now, there's no legal definition for what constitutes an astronaut, but there's a basic understanding that astronauts generally aren't commercial operators, aren't out there to make a commercial profit. So really they kind of fall out of, technically they fall outside of the protections of the rescue agreement. I think it might be inferred within the actual accords, the actual documents, that the idea is these astronauts are performing space resource activities or other commercial non-government activities on the moon will actually be subject to this to the rescue agreement. And this is something a lot of scholars, myself included, have talked about, that basically there's going to be an understanding that astronauts or commercial players are going to be included in this rescue agreement. So understand this is an important one, and again, reinforcing and reiterating current international law and not replacing it or discarding it. Registration of space objects. This goes to another agreement, the registration agreement. And again, it really, reinforces the idea it's important to actually enforce this and have this, register objects per international law. Now, if you recall from my last video, we talked about one of those principles for space resources enunciated by the NASA Advisory Council. One of the areas was registration. So this is kind of where those principles fit into the Artemis Accords itself. But again, this is reinforcing international law. It's not supplanting it. It's not discarding it. It's actually reinforcing it and building on that basic framework. Release of scientific data. Now, if you again recall from last week, I talked about those principles of space resources, and this was one of them as well. In other words, sharing data. So fundamentally, this goes both for governmental missions and non-governmental missions to share this data. And as I mentioned before in the last video, this is something that's basically ingrained in the Outer Space Treaty. So it's this is again building on the Outer Space Treaty, building upon that fundamental framework, and actually reinforcing and enhancing international law through these domestic bilateral accords. Protecting heritage, and this is a new one, and this has been kind of controversial. I've talked about this. I've been asked about this for many years. What about these historic sites like the Apollo landing sites in particular? I mean, do we want commercial players going in there, or even non-governmentals going in there and picking up souvenirs, or basically, stepping on a footprint that's been there for over 50 years and basically destroying heritage? And that's been a huge issue. There's one organization called For All Moonkind, which is actually promoting this. They already have observer status at the UN, and actually they basically recommended and have been supporting legislation that's currently before Congress that would actually require this for commercial actors. In other words, leave this, leave the sites alone, don't disturb them, and so forth. So that's currently in Congress. Actually, the Senate version passed. The House version is, well, it's sitting there and doing nothing right now. So I don't know what's happening with that. But understand, this is something that has been talked about a lot in terms of space archaeology. One of my cherished colleagues in Australia, Dr. Alice Gorman, Dr. Space Junk on Twitter. If you don't follow her, do follow her, because she's a lot of fun, and she is very much at the forefront of this idea of space archaeology. Space resources, and here where I think is the linchpin of the Artemis Accords is space resources, and this just reaffirms the U.S. law, Luxembourg's law, and now the UAE's law, and the idea that space resource extraction and utilization can and will be conducted under the auspices of the Outer Space Treaty, and emphasizes Articles 2, 6, and 11. And I will leave that to you to actually go look at those. I won't talk about them here for the sake of keeping this video short. But understand this, again, my whole rationale, my whole underlying theme for this is both the April 6th executive order and the Artemis Accords are basically setting the stage for space resource utilization and activity by commercial entities on the moon, and eventually for other celestial bodies. I believe that is the actual underpinning of what these accords are all about, setting the stage for commercial activity versus, just strictly government and scientific research. Deconfliction of activities. In other words, we want to avoid harmful interference. And what does harmful interference mean? Well, that's a great question, and we don't have an answer for it yet. It's kind of one of those things right now. We'll know it. We don't have a definition for it, but we'll know it when we see it, type of thing. And this goes into things called safety zones, and these have been talked about. And for example, the building blocks for the Hague resource-based building blocks, which I've talked about and kind of, not been too big of a fan of. They basically talk about safety zones as well. And they bring in Article 9. Now, we talked about Article 9 last week because actually those NASA Advisory Council Principles on Space Resources talks about Article 9. And I kind of discussed Article 9 in this, basically the idea of what sections of Article 9 would apply to this. So, and again, like I said, Article 9, for some portions of it are kind of orphaned. They really haven't been implemented. And how this will be implemented will be interesting because it's kind of walking a fine line. I'm really going to have to do a video on Article 9 to discuss my full ideas about Article 9 in terms of national security and how this could be actually, kind of worked around a little bit. But again, I won't jump into it here because I want to keep this video short. And keep it kind of focused on the Accords themselves. But definitely I'll have to do an Article 9 video probably in the next week or two. Orbital debris and spacecraft disposal. A huge thing, a huge issue. Space debris is a monumental issue, and this right here basically addresses the importance of following the United Nations guidelines that were adopted by the UN. Now, those haven't changed for a long time. Understand the UN guidelines are strictly voluntary. They aren't binding international law. However, other states have adopted the guidelines, and interestingly, the UN guidelines are based strongly on the U.S. Space debris mitigation guidelines. So the understanding is, bottom line is the Accords are going to stress space debris very, very strenuously, not just for low Earth orbit apparently, but also for around the moon. In other words, we don't want a lot of space junk accumulating around the moon as well. What is space debris? Don't have an answer for that. And I don't think the Accords have an answer for that. I don't know. I don't know if they actually define what space debris is. It's interesting. If you recall, I did a video on the UAE domestic space law. They actually define space debris. Space debris is a touchy subject because there really isn't a definition of it or a legally binding definition of it. Again, probably something I want to do. I should do another video on because I do have some ideas on this and making space debris not so much a just one legal definition, but a legal test. Instead of a definition, space debris, whether something is space debris, is a legal test, And again, a very in-depth subject. Maybe I'll save that for another video. I'm definitely chalking up a lot of things that I want to do videos on, but I just got to get to do it. And though that in a nutshell is the Artemis Accords. Again, very interesting. I speculated a little bit last week what I thought might be in them, and it seems some of the principles between the NASA Advisory Council principles on space resources seem to have flowed into it. So not entirely off, but again, that's one of the reasons I don't like to speculate until I actually see it. But again, understand this is an outline, and it's not actually the draft document, the actual draft documents that's used. My guess is what they do with the Accords is similar what the Air Force or Space Command does with I think it's Space Command. Basically, when we make MOUs with other states, other nations for space situational awareness, there's actually a draft form MOU, Memorandum of Understanding, and basically they fill in the blanks, and some of them are customized for each individual nation that they do a space situational agreement MOU with. So I'm thinking that's kind of what these Artemis Accords are like in term. There's basically a boilerplate draft, and you fill in the blanks in some cases and modify the language as needed for each state. And again, I think bilateral agreements are very important for this type of for outer space development, because it's easier dealing one-on-one with a country to address the cultural differences that another country may have, and actually tailoring an agreement to that, instead of trying to take one agreement and tailoring it to the cultural and actually the state interest of other nations, multiples. It gets very confusing, and it really makes for ineffective documents and things that can provide a lot of loopholes. But again, I'm excited about this. I'm going to use a term that a friend suggested. This is the new playbook for outer space activities, in my opinion. Treaties are pretty much going to be few and far in between, in my opinion. It's ideas of using bilateral agreements like this and partnerships that are negotiated outside of the UN system that are going to be the new playbook and the new way of doing things in the years to come. And I think it's really the best way to get things done. So anyways, I'm going to leave it at that. I am going on the space show this afternoon, and by the time you see this video, I probably would have done it. So what I'll do is once the podcast for the space show comes up, I'll make sure to post a link in the description as well, so you can go and listen to the show. I'm going to be talking about the EO, the April 6th EO, and I'm going to be talking about the Artemis Accords. We're going to talk about a lot of other stuff. They're always good shows, and I encourage you, if you're listening to this video before the show, to tune in, and if not, follow the link that I'm going to post so that you can go listen to the podcast afterwards. So anyways, it's a great day there. I'm going to go enjoy some sun and maybe do some work outside before I appear this afternoon on the space show. And again, stay healthy, stay safe. Yes, I got a haircut last week, so that was a highlight of my last week, was getting a haircut, and we're moving forward. Until next time, see you soon.